Standing analysis becomes more difficult when the risk is a statistical risk or risk in the future that may or may not occur. And finally, in the most attenuated problem, the fear of future risk. If we think about sort of classic tort cases where someone is exposed to a dangerous element, radiation is very characteristic, that is not low enough to injure them today, they still will have a significant risk of cancer in the future. So if you were bringing a tort case on behalf of this plaintiff, your damages would be the creation of the risk of future injury, and it would be quantified for monetary calculations based on what's the type of cancer, how great is the risk, and a reasonable component of that would be the legitimate fear today of the cancer that would develop in the future. These would be straightforward and easily supportable in this sort of case where we have a sufficient exposure to a toxic element with known future hazards and fairly good understanding of the probabilities of future risk. It's more difficult in many administrative law cases, particularly environmental law cases, is that we may not have this very good data. Now, the smaller the risk as a probabilistic risk, then the harder it is to make the Luan standard for causation. If assume that we have an agent that causes cancer, but the risk is quite low. It might be one cancer per 250,000 people over a lifetime. If we had an individual bringing the lawsuit, then that individual would not be able to show any reasonable likelihood of getting the cancer. This would be essentially lower than most background levels of cancer from things like radiation in the environment or other environmental risks. On the other hand, if you were a large organization with a lot of members, say the Natural Resources Defense Council, if you had 500,000 members, then it's statistically at least 2 of those could expect to have cancer over a lifetime. And in one case, this was found to be enough to create standing to challenge the regulations. In the NRDC case, where the risk of cancer is only 1 out of 250,000 over a lifetime, a rational person would not worry about that risk. But we know that people are unreasonably frightened of low-level risks. We may have people that are legitimately frightened, meaning that they are frightened even if their fright is irrational of these kind of risks. This is a very difficult issue for the courts to deal with. The courts are particularly concerned about this because fear is easily manipulated by lawyers. We saw this in the BP spill, where there were many beaches and the like closed, even though there was actually no oil on those beaches, where people in toxic landfill cases are frightened to live anywhere in the area of the landfill, even though the best science shows that they are at no risk at all for the landfill. So the courts have to figure out, when is fear legitimate? How do we try to quantify this for standing purposes? The easiest case is if there is in fact a plausible or rational reason for the fear. There's an old case of Laidlaw, environmental services, where there was a violation of a clean water permit dumping into a river. The permit itself establishes the level of allowable exposure, and that the violation of the permit shows that this level was exceeded. The permit also shows that the chemical was recognized as dangerous to human health. So despite the fact that the diluted chemical in the river might not be that hazardous, it was perfectly reasonable for people to be frightened of swimming in the river when it's polluted by these permit violations. The question, though, is how far away should this plausible fear go? how far downstream, what if there's a lake that intervenes between the swimming hole and the original exposure. And then we finally saw in the case we discussed in class that the dumping was in the Gulf of Mexico, and the plaintiffs were essentially arguing that they were frightened of the pollution everywhere in the Gulf of Mexico. Somewhere between the initial dumping and diluting out into the entire Gulf, the courts are going to have to draw a line. In 2007, the D.C. Circuit began to narrow the use of fear in Public Citizen versus National Highway Safety Administration. This case, the court is really looking for much greater quantification of risk. They want to see proper numbers on the statistical chance of risk, the nature of the toxicity. These are difficult numbers to get, and they effectively mean that it'll be more difficult to bring citizen suits where a significant component of the injury is based on fear. The question is, where do we go after Public Citizen? First case really looking at this is Summers versus Earth Island Institute. This is a procedural change in rules on qualifying public land for timber cutting. The part of the case was settled, and thus after the settlement there were no future permits for cutting available. And at this point the court dismissed the plaintiff's suit, arguing that no one had standing. Well, the plaintiffs argued that there'd be timber cut in the future, and at that point, they would certainly be able to find a member who had a sufficient geographic nexus to have standing. But as the court ruled, they couldn't do that today, and in fact, there was no imminent injury until a new permit was issued for cutting. Now, we'll see later this could also be seen as a ripeness problem. Monsanto versus Geertson seed. This is a fight over genetically modified alfalfa. Organic farmers have to be able to certify that their crops are free of contamination with GMO organisms. The farmers were concerned that if the Department of Agriculture deregulated the planting of genetically modified alfalfa, they would not be able to know if their neighbors were growing GMO alfalfa. If there is a neighbor growing GMO alfalfa, the farmers have to take a lot of precautions to protect their crops. They need to test their crops, and they may even need to dispose of crops from certain fields if they find they're contaminated with GMOs. If they try to sell GMO contaminated alfalfa and it's determined by the buyer that it's contaminated, then they may not have credibility to sell in the future. So they were saying that if this deregulation goes forward, they're going to have to take these expensive precautions at all times because they will not be able to know when they're at risk. Supreme Court bought this argument that these current precautions, which have real costs, were a reasonable response to the risk in the future of the genetically modified organisms being grown next door. However, in 2013, the Clapper case comes along. This is a national security case, and it's always difficult to see these as precedent because there is so much deference to the government in national security cases. But Clapper is a classic chain of causation problem. Plaintiffs are journalists and lawyers working with suspected terrorists. Some of them were defense lawyers concerned about the invasions of the attorney-client privilege communications through surveillance. The journalists were concerned that if they had a reputation of having their communications surveilled, that no one would be willing to talk to them or give them information as sources. They believe that the NSA is clandestinely surveilling their various electronic communications. They're following the Monsanto arguments in that they argue that they have to take expensive precautions. These included traveling to foreign countries rather than using the telephone to talk to people. It meant using handwritten notes rather than electronic email. It may mean that they're actually can't travel with their computers and need to send their hard drives by other secured messengers that are not subject to surveillance. There were a lot of claims of the reasonable precautions you would take if you were concerned about your communications being clandestinely surveilled. The government's defense in this was to argue that it was very unlikely that the surveillance was going on. And first, as they say, it was highly speculative that they'll target the specific people, that there are other programs that they could target them with rather than the one they were challenging. And finally, even if the government were going to target this type of surveillance, whether the FISA court would actually sign off on the warrants to do the surveillance. Now, the plaintiffs can't get any discovery on this because all of the information about surveillance is a national security issue and thus would be classified. The majority in the Supreme Court in Clapper found that the injury was too speculative and denied standing, that there'd be too many different things that would have to happen before the surveillance would happen. Now, we can read this as the court's bias towards government and terrorism cases. It can also be read as being especially deferential because it involves separation of powers. Fundamentally, is the executive branch lying about surveillance? Ironically, shortly after the Clapper decision, Edward Snowden showed that they were in fact conducting their surveillance and conducting it on almost everyone, certainly including the journalists and lawyers that were plaintiffs in the case. The practical implications of Clapper are still difficult to determine. If you just read it as a special national security case, it probably doesn't have a lot of significance. If it's a Supreme Court telling us it is going to dramatically narrow standing, then it's fairly troublesome. It's fairly easy to distinguish Monsanto because we know that if the alfalfa is deregulated, then it will be grown along with regular alfalfa, and farmers will not be able to know whether their neighbors are growing it. The NRDC case, modified by Public Citizen, may be much more problematic under Clapper. It may mean, in fact, that the court is going to require individuals to be shown to have some specific risk of cancer rather than this generalized risk among the tens of thousands of members. If that's the case, it could be the death knell for many citizen suits in environmental law. As a practice matter, plaintiffs need to make their causation as simple as possible to try to avoid Clapper.